Welcome, everyone. Thank you for joining us for today's webinar. My name is Amy Brown. I am the AmeriCorps Vista working with Open Media Foundation. I help manage the Career Engine program, which is a supplemental HR service aiding media and journalism organizations in targeting and hiring more diverse applicants, as well as convene two working groups centered around diverse hiring and retention and media engagement. So just a little bit about the Open Media Foundation, if you had this invite forwarded to you and don't know about us. We are an innovative media and technology nonprofit organization dedicated to putting the power of the media in the hands of the people. And to accomplish our mission, we begin with providing affordable, high-end media and technology services. And we follow up by offering training such as this one and tools that enable everyone to represent their own voice in the media conversation. So today we are presenting Understanding the Criminal Justice Record Act and How to Pry Records Loose. And this is going to be instructed by Rachael Johnson, a legal local initiative attorney working with the Reporters Committee for Freedom of the Press, and Jeff Roberts, the executive director of the Colorado Freedom of Information Coalition. So just a little housekeeping before we get started. If you have any questions during the presentation, please type them in the Q&A question box in your Zoom control panel, and we will have time for questions at the end. For those that submitted questions during registration, we will do our best to address them throughout the session. So now, without further ado, we will turn time over to Jeff and Rachael. So just to provide a little background about our presenters, Rachael Johnson is a local legal initiative staff attorney based in Colorado. She has a decade of experience working in both the legal and media fields, and she has represented pro bono media clients from the Berkman Klein Center for Internet and Society's online Media Legal Network, that's a mouthful, as well as directed the Federal Communication Team's review of documents sought through Freedom of Information Act requests at the Natural Resource Defense Council. Very well-rounded. Before that, she served as a senior writer and creative communications advisor to U.S. Department of the Interior Secretary Sally Jewell. Rachael has worked as a reporter, editor, and producer, and she is a graduate of the University of Denver Stern College of Law and is a native Coloradan. She received her master's degree from Columbia University, Graduate School of Journalism, and has a bachelor's degree in journalism from Hampton University. Jeff Roberts worked in journalism and public policy before joining the Colorado Freedom of Information Coalition. In July 2013, he was at the Denver Post from 1984 to 2007 as a reporter, assistant city editor, and data journalism specialist on the Post project team, and later spent 4 years at the University of Denver's Center for Colorado's Economic Future. Early in his career, Roberts was a reporter at the News Press in Fort Myers, Florida. He holds a bachelor's and master's degrees from Northwestern University. Alrighty, Rachael and Jeff, I'm going to let you guys take it away.
Okay. So I just wanted to make sure that everybody knows, if you don't, what the Colorado Freedom of Information Coalition is. We are a 501c3 nonprofit, and our primary mission is to educate the public and the journalism community in Colorado about their rights under the open government laws, so the open records laws, the open meetings law, court access, that type of thing. And we also advocate for government transparency. I am going to, actually the first thing I want to do before I forget is I have a handout. So I'm going to put that in the chat. And I don't know if we'll have to repost it later if people join. I know sometimes they don't show up for people who join later. But I have some slides and I'm going to share my screen. Everybody can see that okay? The slides? All right, that looks okay, good, thanks. So we're talking today about criminal justice records. I know that everybody's probably heard of CORA, but a lot of people don't necessarily know that there are two records laws in Colorado. There's the CORA and the Criminal Justice Records Law. This slide just shows all the different legal grounds for access to different kinds of records and the open meetings law in Colorado. But CORA, which you may be more familiar with, covers all state and local records except for criminal justice records. And so we have this separate statute called the Criminal Justice Records Act, which was enacted in the 70s, that governs access to police records, other law enforcement records. And the huge difference between the two is the presumption of openness. CORA, you can presume that the records that you're seeking are open for inspection unless there's something in the statute that says that they shall be withheld, can be withheld, or there's some court decision about that. It works differently in the criminal justice records law, and we're going to go into those differences. So there are two primary types of records in the Colorado Criminal Justice Records Act. There's a section on what are called records of official action. It's actually sort of a smaller subset of criminal justice records. And that's pretty much your basic arrest report. So the arrest report that would show, for instance, just the name of the accused person, the date the crime allegedly took place, the person's birth date, their address, and the charges brought against them. It's pretty basic information that's in that record of official action, that arrest report, that must be released. And that's the big difference there. Those records must be released. Most other criminal justice records, the records custodian has discretion to decide whether to release the records. And so in making that determination, and some of you have probably made requests for criminal justice records and you've found this out, that they can be denied if the agency determines that disclosure would be contrary to the public interest. So they can't just say that. They're supposed to weigh various factors in making that determination. There's a Supreme Court case that came out of Columbine called Harris v. Denver Post that lays out this balancing test of factors. So there's several of them in there, but the main ones are any privacy interests of individuals in their witnesses, for instance. A big one is the agency's interest in their ongoing investigation, and then the public interest. So whenever you are requesting criminal justice records, you are doing it usually as a journalist, you're doing it on behalf of the public, and your interest is the public's interest. And sometimes you might have to explain what that is in order to get these records, because you want them to weigh that, and you want them to give substantial weight to that. And as a case is being investigated, you maybe, as it gets closer to the end of that, you may have it may be more likely that you'll get the records, because that ongoing investigation interest starts to weigh less, and the public's interest hopefully starts to weigh more. There's a subsequent Supreme Court case that's also useful regarding redaction of criminal justice records. And basically, if there are privacy interests in records, in criminal justice records, the court said that a records custodian should use redaction to withhold that portion of the record while making the rest of it available for public disclosure. So we always try to make that argument if we're just getting shut down completely, that, hey, there's these court decisions, and sometimes it's helpful to do that. We talked about the basic arrest report. The record that you usually want when someone is arrested is the arrest affidavit. And so that is not a record of official action. It is in that broad category of criminal justice records that could be withheld using the records custodian's discretion. The arrest affidavit, as you probably know, is the meaty, interesting information. It's the reason, it lays out the reasons why someone was arrested. And that's what you want for your story often is that kind of detailed information. And so sometimes those are sealed, sometimes they are just withheld as a investigation is ongoing. So you may have to ask multiple times for these records in order to eventually get them. Another important record, and this law has changed recently. It used to be that internal affairs records. So when an officer is accused of some sort of wrongdoing and there's an in-house investigation about what happened with that officer, it used to be that practically every law enforcement agency in Colorado would withhold these records as contrary to the public interest. Denver was sued many times over this, and about a dozen years ago or so decided we're going to make these available. But we practically, no other agency did. We worked with University of Denver Law on a study a few years ago, which showed that they made many records requests and got very few records. That led to a new law in 2019, which makes completed internal affairs investigative records open for public inspection. Great change. It really helps you do reporting on police who are accused of misconduct. There are limitations to this law, and I've pointed them out in articles that I've written for my blog. Some agencies are very specific that you have to ask for records about a specific incident involving a member of the public. So if you asked the Loveland Police Department, for instance, and that's an agency that's under a lot of scrutiny right now, if you ask them for all their IA reports, for the past 2 years, you're likely going to get a denial because they'll say, well, you have to ask for a specific incident. If you ask Denver, if you did a records request for Denver, you are going to get those records. They have a policy to release those. So we think the law could be made better, and we're trying to do that. Body cam and dash cam footage has also been one of those criminal justice records that can be withheld if the agency determines that disclosure would be contrary to the public interest. It is still that way at the moment, but under Senate Bill 217 passed in 2020, that's going to change. So starting July 1st, 2023, there's going to be a time element put into the law. It's in the law, but it will go in effect then. And so when there is video regarding a complaint about an officer or officer misconduct, it has to be released it has to be released no later than 23 days after or 21 days after the complaint is made. And they can extend that if there's still an investigation going on, but it will have to be released. And that's going to be a big change because right now it can be delayed and delayed and delayed. Or they'll release it, pretty much when they want to. If it shows something they want to get out, they might do it that way. Another important, it's not really a criminal justice record, but it's very much related to criminal justice records. This is under a separate statute, are jail logs, and just something to know about if you suspect that someone has been taken into custody, the jail log is always there to take a look at. It has to be available to the public at all reasonable hours, and it includes some pretty important information about who's in the jail, and what the charges against them are. They just updated this statute a couple of years ago, and there's actually a whole a large amount of information that has to be kept now that will be made available to the public. It's a otherwise it was a pretty old statute, 100-year-old statute, but you're entitled to know, we're all entitled to know who is being kept behind bars. Autopsy reports are not criminal justice records. They are CORA records, so you actually have a better chance of getting them. They can't be withheld. If there's been an autopsy report on a homicide victim and it's completed, you can request it under CORA, and they can't use that contrary to the public interest to withhold it. The coroner could go to court and ask a judge to withhold it, but they can't just do it themselves. So those do get mistaken for criminal justice records. Sometimes, as recently as 2 years ago, there was a lawsuit over this, but we usually win those cases. Cost of criminal justice records, it's a little less precise than what you see in CORA. CORA is agencies are allowed to charge up to $33.58 per hour for research and retrieval after the first hour. Criminal justice records, they may assess reasonable fees not to exceed their actual costs for research, retrieval, and redaction. So what does that mean? It's very hard to understand, when you're told that a report will be $250, how do you know that that's really their actual cost? It can be kind of frustrating sometimes, or that body cam footage that you requested, that can be an issue. And so it's helpful to just know what the law says, and maybe to throw it back at them and say, please explain how that is not exceeding your actual costs, please. And maybe you'll have some luck getting that reduced. They are supposed to require you to sign a statement saying you're not going to use the records to solicit business for pecuniary gain. That's in the law, and that does not mean journalism. So if you sign it, it's really not a big deal. I think you can your news organization can sign these. I think every once in a while. I'm not sure if you have to do it every single time, but you might. If you have to do it, don't be surprised. And then if you get denied records and you think that you've been wrongly denied the records, like in CORA, your recourse would have to be to go to court. If you've made all these arguments and it just hasn't worked. But it is harder to get court costs and attorney's fees if you win, and basically to win one of these cases, you have to show that the records custodian abused their discretion, and Rachael can probably talk more about that. But it's a harder thing to show. As long as they show that they have weighed all the factors, then it's pretty difficult to win one of these cases. Juvenile justice records, that law changed a few years ago. It used to be you could get the name, and even if you weren't going to ever use it in a story, you could get some identifying information for juveniles who were charged with very serious crimes but not charged in adult court. That law changed in 2017. So really now the only way to get that information in a record is if that juvenile is charged in adult court. Really basic stuff about writing the letter. We have a template on CFOIC's website that includes both the statutes for CORA and CCJRA. You always want to ask for an estimate of how much this is going to cost me. You always want to ask for a written explanation of the grounds for denial if they're going to do that. One thing I think I neglected to mention is that there is no time limit for response in CCJRA other than for records of official action, which is 3 working days like in CORA. For all other criminal justice records, they can take their time. And the only real time in there is if you are going to be denied, you can ask for that explanation and they have to get it to you within 72 hours. But it's kind of useless because you've already been denied and they can just say, we've conducted this balancing test, etc. So the time limit thing is something we'd like to get changed in the law. There will be something in there about body cam footage starting in 2023, so that's good. But all other records, it's kind of a frustrating thing. All right, I am going to unshare my screen and turn it over to Rachel.
Hi, everybody. And, Jeff, thanks so much for that primer. I think it'll beautifully set up some of the hypotheticals that will be really helpful to apply what Jeff has already chatted with us about. So, Amy, I'm wondering if you can share your screen again and pick up where Jeff left off. That would be awesome if that's possible. While Amy is doing that, I can just maybe tell you briefly a little bit more about RCFP. The Reporters Committee for Freedom of the Press, we provide nonprofit pro bono legal assistance to journalists in order to support First Amendment freedoms and news gathering rights of journalists. So let me also add our site to the chat so folks are aware of where to go. And I'm pretty sure you're already maybe familiar with RCFP. I'm the local legal initiative attorney, like Amy mentioned. And so I'm based in Colorado. So a lot of my work is public records work, and but it can be a variety of different First Amendment legal issues that come up. So don't hesitate to reach out to me or RCFP if you have issues that are related to Colorado or in different states. We'll be happy to help. Okay, so I thought I would start with a hypothetical, which, and I should probably preface this by saying, have to do the lawyer preference thing, that these are hypothetical scenarios. I'm not offering formal legal advice here, and this doesn't replace the advice of an attorney. So why don't we just go ahead and start with the first hypothetical. All right, so I'll read it out maybe, and then if folks want to chime in and just give what their thoughts are, we can do that. And then after that, we can go over what the answers would be. And Jeff, feel free to chime in as you'd like as well. So let's just read this really quickly. Aaron James is a reporter for the Denver Chronicle, and he's working on a story about the tragic death of a well-known local musician and artist who died under suspicious circumstances. James does a little research. He calls the Maple County Coroner's office and politely requests a copy of the musician's autopsy report from the coroner. The Maple County coroner tells James, he's busy, call me back in a couple of days. A few days later, and instead of calling again, James follows up by sending the coroner an email with his request. And when the coroner responds to James, he CCs the Maple County attorney, and the attorney denies his request for the autopsy report on the spot. And what the attorney says is, you know, or what happens is the attorney doesn't really bother to cite a statute for the reason for the denial of the request and just says, you'll have to get a court order for the autopsy report. So I guess we can kind of ask the question, is Aaron entitled to the autopsy report? Any thoughts on that? And if not, I can just jump in. I'm sure folks may already know the answer based on what Jeff just told us. So I'll just go right through. So yes, an autopsy report, or Aaron is entitled to access to the autopsy report. You know, like Jeff said, they are not criminal justice records. They are open records and governed by CORA, not CCJRA. You know, sometimes custodians will deny access to autopsy reports, saying that they're medical or health records, but the statute in Colorado specifically exempts autopsy records from that statute. So under CORA, coroners and autopsy reports they're specifically excluded. And that exemption, I can just drop it in the chat so you have some reference, is, let's see, let me make sure I'm getting this to the right. I think it's all panelists, is that right? Okay. Or
it'll be all panelists and attendees.
Oh, okay, let me give it there. So I'm making sure I'm giving it to the right person. Okay. So that's the relevant statute if you are given pushback from an agency who says, hey, these coroner's reports or these autopsy reports are excluded, or we cannot disclose them because of the medical or health records exemption. So it does not apply in that situation. So you would have access to the autopsy reports. You do have a right to that. I mean, there are some limitations with getting access to autopsy reports. You know, Jeff mentioned if there's potentially an ongoing, if there's a homicide victim, you know, sometimes the autopsy reports can be held from public inspection by a custodian under, you know, and they can deny access based on substantial injury to the public. You know, and that's really based on the Freedom Newspapers Inc. v. Bowerman case. But it's pretty tough to push back on that substantial injury to the public interest. You know, I think Jeff also mentioned the Columbine case. The judge did deny access to autopsy records because of the unique public grieving in the immediate aftermath of that shooting, that records could be denied for that reason.
But the judge, or I'm sorry, the coroner is the one that has to go to court.
Right,
correct?
right.
Yeah, and that's the difference. Is that it's really it's sort of the tables are turned, and to withhold it, they're the ones who have to seek the court order, not the other way around. There is a question in the chat about autopsy reports.
Oh, okay.
What about an autopsy report when the coroner has not ruled the death a homicide? I know the case law really refers to homicides, but is it any autopsy report?
You know, that's a good question. You know, if it's a homicide, that's when there's an exception. But generally, autopsy reports are disclosable. Yeah. So you should be able to request those records, and the agency does have they have to respond and turn that over under CORA.
As long as it's completed.
Right. I mean, yeah, if the report isn't completely complete, then there might be a reason why they would not turn it over. But generally, you should be able to get access to an autopsy report if it's not related to a homicide. And another interesting, just quick fact, and then we'll move on because I know we're looking at time, but autopsy reports are not within the investigatory files exception to statutory requirements for disclosure of public records. So, you know, and this was in the Denver Publishing Company versus Dreyfus case. They're not, autopsy reports aren't part of an investigative file. So that's what makes them a little bit different from records that would probably be withheld from the public during an investigation, like court records or something like that. But with autopsy reports, because the court in Denver Publishing said that they were not an investigatory file, they should be disclosable. The other couple things I wanted to quickly note that the custodian maybe didn't completely do correctly in this instance is that, you know, under CORA, a custodian should provide the records to you immediately. You know, if they aren't immediately available, the custodian typically has a reasonable time, which is 3 working days, to give you access to the copy of the report. And so another thing that Jeff pointed out earlier is that the custodian or the attorney in this case should have cited the grounds for the denial, which is helpful when you need to appeal or litigate a denial of a court request. Are there any other questions related to that hypo? Okay, great. So I guess we can go to number 2. Thanks, Amy. Okay, the second one is Jody Smith of Colorado TV News submitted a CCJRA request to the Maple Fire Department for access to body camera footage of a young man who died after being administered ketamine. Her request was denied by the Open Records Coordinator at the Maple Fire Department on the ground that there is an ongoing internal review of the fireman's actions. The records coordinator tells her to try back in a few weeks. Jody waits a month and requests the footage again. The custodian denies Jody's request. So any thoughts on how Jody should respond, or maybe what her first step should be in potentially pushing back on this denial? Okay, Elise chimed in and said, ask for grounds of denial and cite the 2019 law stating internal affairs are public. That's a really good way to push back. You know, as Jeff was mentioning earlier, it doesn't hurt in your CORA request if you're responding to push back with citing case law or the relevant statute that would kind of call the custodian, I guess, to the carpet if they're not correctly denying your request. So that's one way to push back. You know, and you can look at this holistically and say, hey, you know, Jody would first want to figure out if the records are records of official action. If it is a record of official action, you know, the custodian must turn over the record. And, you know, Jeff went over this briefly. If it's a record of an arrest, an indictment, a release from custody, parole decisions, sentencing decisions, and the like, or not in the like, and dispositions of cases are typically records of official action in which the custodian does have to turn over the record. But body camera footage is not considered in that first group of records of official action. So the custodian does have discretion to deny access to body camera footage. Probably not what you'd want to hear, you know, when seeking body camera footage. And Jeff also mentioned that there's a law that's going to go into effect in 2023 that kind of would not completely change, but it would allow less time for the agency to, you know, not turn over the footage. So they would have the 21 days after the complaint is made to turn over the body camera footage to the requester. The other good option for Jody when she's submitting a request like this for body camera footage is when you're submitting your request, try to include the best possible argument as to why the information should be available to the public, because what the custodian is doing under the contrary to public interest exception is weighing the public interest versus the private interest. So if you can initially in your request cite a really good public reason or reason why this information is important to the public, you might have a better chance of getting the body camera footage released.
I would also add that for a fire agency, I would request records under Cora as well, because they may not be considered a criminal
Law
justice
enforcement
agency.
Yeah, usually a criminal justice agency is an agency that, you know, they're taking on activities that are directly related to the investigation or detection of crime.
Yeah.
So, you know, it's kind of a gray area.
Because they might be investigating arson or something. But
yeah, they could be
yeah.
investigating something that's not, you know, it could be related to a crime, like arson is a crime, so they could be investigating that. But if it's something completely outside the box of investigating crime, I would certainly agree with Jeff and just also submit a Cora request, because those records could come out under Cora.
Or do it under both.
Or do it under both, right?
Our template cites both.
Yeah, you should cite both. I mean, generally it's a good idea to cite both. I think it's rare that you just want to cite CCJRA or just Cora. So I think it's always a good idea to just request the records under Cora or CCJRA. Okay. And the next hypothetical number 3. Okay, thanks, Amy. So a reporter gets some good news here. After waiting 3 days, he will finally get access to an arrest record of a well-known CEO who was recently charged with a DUI. But there's one caveat. The records custodian says that in order to release the arrest record, it will cost the reporter $20 under their research and retrieval fee. What can the reporter do to avoid paying the $20 fee? Any thoughts on that? Well, one of the things I'll kind of just reiterate, you know, these the arrest records are considered records of official action. So they must be released for the public inspection in their entirety. It's best always when you're submitting a Cora request to include a request for a fee waiver. You know, under Colorado law, you can request a fee waiver. They are allowed, but a custodian is not required to grant that request. So that can be unfortunate. You can also request a fee waiver, you know, if you didn't submit in your original request, you can always follow up and say, hey, can you waive the fee? And sometimes a custodian is, you know, can go ahead and waive the fee. Usually that doesn't happen, but you would also want to cite that the information is being used to serve a public purpose, a journalistic purpose. The other thing that kind of why I thought it might be a good idea to include this hypo is because there's a research and retrieval issue here. And that's a little not concerning, but you know, if you're in a situation, you know, where this is a pretty easy record to retrieve, you know, this is it's an unfortunate thing that occurred with the DUI, with the CEO getting a DUI. If that was a recent, you know, request, you could probably get the records pretty quickly. So, you know, you would want to look at the research and retrieval reason why the custodian is citing that, because usually when you're citing research and retrieval requests, they're based on the time that it takes for the custodian to find the record and determine whether it should be released in whole and part. And if it was a recent incident, you know, they shouldn't really be, you know, needing to find the record or determine whether it should be released in whole and part, especially if it's an arrest record that should be released right away. So you could push back on that. You know, there are fees involved, unfortunately, with requesting some of those records, you know, but it would probably be applied under the cost to copy a record, which under Colorado law, the cost of a copy can't exceed 25 cents per standardized page, or the actual cost of providing the copy. So, you know, I would kind of push back and say, hey, this was a recent request, if this is applicable, and the records are records of official action, those records should be turned over immediately or released quickly. So I'm not clear on why you're charging a research and retrieval fee in this case.
This one can get pretty frustrating. About 3 years ago, I think, there was a state legislator who was arrested for allegedly, I think, providing alcohol to minors, and I think she was maybe recently cleared of that. But the police department was charging news organizations $250 for the arrest report, and they charged $250 for each arrest report. And I heard from a few reporters about that. Some of them who just said, we can't afford that. And it was, so I was trying to think of a way to push back on that. And it was like, well, ask them to explain how this is their actual costs when they're charging 10 or 12 different news organizations each $250. And, it's, to me, that's wrong. It may disadvantage the first requester, but the ones after that, the record's there, it's been made.
Right. And I mean, another principle to think of under CORA is, fees should never, like Jeff pointed out, should never exceed the actual cost. And so the government, that really means that the government agency can't profit off of the fees charged for copying records, because, the public already owns and already has paid for those records technically. So they shouldn't be charging anything more than what the actual cost is to produce the records. Another thing is, you might want to take a look at the agency's fee schedule. They should be complying with their fee schedule. If they posted something online, they should be complying with that. And if they're not, then that's obviously a problem then, and you can push back in that way as well. So our final one before we'll go to questions, and maybe I extended this a little bit too long, is with the reporter Harry Milton, who's a freelancer. He sent a records request to the Eastern Police Department after learning that one of their police officers had allegedly harassed a woman on the police force. In this request, Milton sought access to the officer's disciplinary records. When he sent his request to the EPD denied the request on the ground that the police disciplinary records were part of the officer's personnel file, and those were not subject to disclosure. Any thoughts on what a reporter can do to push back on this request? Well, first, I just want to point out that if you're seeking disciplinary records under CORA are open records. It can be a little different under CCJRA, but personnel files under CORA means only information that is similar in nature to an employee's home address, their telephone number, and personal financial information. That's properly classified as personnel file, and that information is usually not disclosed. So in this case, it's the reporter isn't seeking the home address or the telephone number or personal financial information. So technically, those records, if they're under CORA, would be open records. Now, I know under CCJRA, the new, I think it's the House Bill 19119, about officer disciplinary records. And Jeff, correct me if I'm wrong here, but these records are not personnel files.
That's correct.
And in refusing to release these internal affairs reports, sometimes the enforcement agency can cite that they're personnel files, which would not be correct. And the new law specifically states that those internal investigation records really apply to examining an officer's in uniform or on duty interactions with them, with a member of the public. And so, you know, when trying to get access to those files in the future, they might there might be some pushback, you know, if it's not related to a member of the public. Here, it's a little bit squishy because the person who we're seeking information about is also on the force with the police officer. So that can be a little bit more challenging. I think that might be all I have on that. I just wanted to double check. Okay. All right. Well, that kind of concludes the hypos in this situation. And I guess we could take questions.
All righty. If you have any questions, feel free right now at this moment to go ahead and put it in the chat if they haven't already been addressed.
What was so close to time here?
All right, I don't see any additional questions. I will give, oh, there we go.
Wait, oh,
I see one from Sandra Fish about.
I see a couple actually. It just popped up on my chat. All righty. So yeah, Sandra, like Rachel said, do these laws apply to campus police officers too?
You know, that's a really good question. Some universities and colleges hire security personnel, others hire, you know, certified sworn police officers. So a lot of large colleges and universities can pretty much use law enforcement that is from their local, county, or state counterparts. So it kind of varies on what information you're seeking, but generally, if it's a state police force that's operating on behalf potentially of a private university, some of those same rules would apply to that, to the police agency if it is a state police agency that's being used on a private campus. You know, and I don't know if Jeff has any other thoughts on that.
no, I think that covers that. I mean, if they're performing a law enforcement function, they're a criminal justice agency, and they would be treated the same way. So yeah. There's another question about compelling agencies to respond more quickly to requests 6 months or more, you know, that aren't records of official action. Yeah. Yeah, I wish.
Frustrating. Yeah.
You know, that's one of the things we would absolutely like to see changed in the law, and we've been trying to get some interest in that. I think that we can make the case that you know, once an investigation has wound up, that there should be quicker access to these records. You know, we'll have that change with body cam and dash cam footage, but there's a whole, you know, there's all sorts of other criminal justice records that you know, can be requested, and they take their time on. So, you know, I don't know that I have great tips about that other than to, you know, point it out in your news stories, trying to put pressure on on whatever agency that's dragging their feet on particular records. I want to also mention something else that's going into effect in 3 days that, is going to, is also going to be relevant with some of these records, which is the new sealing and suppression standard for the courts. If a record is going to be sealed or suppressed, if a judge has to explain themselves more so than they have in the past. And also these requests to seal and suppress records will have to be docketed. So you'll see that. You'll see that there's something there. The request is there. And if there's going to be a hearing on that, that will have to be docketed as well. This has not been the case necessarily. It's been very haphazard with the sealing and suppression of records. And so this is hopefully will you'll just know, you'll have more of an explanation and if records are sealed by courts.
Alrighty, I have an additional question. This is from the registrant form that I'm not sure was clearly addressed, but it says, is it possible to get records from nonprofits that accept government state funding? How can we hold these organizations accountable and ensure transparency?
So nonprofits, and you're not talking about a nonprofit that is involved in some sort of criminal investigation or something. I don't know what that would be, but this is more of a general question about nonprofits. Is that right?
Mm-hmm. And whether or not if they accept government state funding.
Yeah. So very, very few nonprofits would be covered by CORA. There is some case law about this, and it was involving the Denver Post suing the Stapleton Development Corporation back in the late 90s. And I think the Supreme Court issued a ruling in about 2000 on this. And because this is the nonprofit that was set up by the city and county of Denver to develop the old Stapleton Airport property, and because the city had such control over this nonprofit, appointing the members of the nonprofit board and things like that, the court ruled that this nonprofit is covered by CORA. But so there's sort of a test that's outlined in this case, and it really has to do with how close the entity is to the government and if it's performing a governmental function. Just receiving money from the government itself does not necessarily make it subject to CORA. And the example that I used for that is there are 20 nonprofits in Colorado called community center boards. And these are the nonprofits that coordinate care for people with developmental and intellectual disabilities in Colorado. These are nonprofit boards. They get 80 to 90% or more of their funding from the government, and they're not subject to CORA. There was actually a bill in the legislature about this a few years ago to make them subject to CORA. It passed, but without that provision, and it only says that certain of their records are public. So the legislature even looked at that and decided not to make them subject to CORA, which was disappointing, I thought, but just that funding aspect of it doesn't make the difference.
Yeah, it's typically tied to funding and how they receive their funding.
Thank you both.
I hope that answered that.
And then this next question, if your request is turned down, is there a process to appeal the decision?
I know that answer pretty well. Yeah, unfortunately, no. Colorado has no appellate process if you're denied a CORA request. Some other states do. I know Pennsylvania has an appellate process, but Colorado has no process if your CORA or your CCJRA request is denied, the only real option in that case is to move forward and litigate and go to court, unless you can get someone in some limited cases. It's really helpful to have a demand letter sent on behalf of an attorney to the agency that denied your request. But in general, the only recourse against that agency is to go to court and litigate.
Thank you.
I'm seeing another question here from Brian Berger about statutes of limitations or time deadlines for requesting CCTV or body cam footage. I don't know that there, and Rachel, you may know this, I don't know that there is any kind of time, statute of limitations. It may just actually be whether the record still exists. So with body cam footage, it takes up a lot of space on drives. And so they may have a policy in place that some of the footage is deleted every once in a while. And so that actually may dictate whether you can request the record. They cannot delete a record after it's been requested. There's case law all around the country, I think, about that.
Yeah, that's problematic. Yeah, I mean, I guess if the ask is related to, is there a statute of limitation to request that, there's really no, statute of limitations to request records. There's also no time limit with request of filing suit. In some cases, what can happen is if you if you go to the process where you do have to litigate and you've gone through being able to have the agency have a meet and confer with the agency before you file this notice of intent to file an application. You go through the meet and confer process, then you decide that you're going to file the application or the complaint. And, maybe something happens during that time and you have to wait a while. Usually what happens is that the time resets. So you're not prevented from, filing suit on those types of issues. But, I hope that answers your question. That might have just completely muddied whatever you were asking. So I hope that was somewhat helpful.
There's a good response in the chat about the nonprofit question, that if a nonprofit receives funding from the Scientific and Cultural Facilities District, you can get those records from the district. That's a good way to think about it, that if a nonprofit, first of all, you can always see, I should have mentioned that you could look at a nonprofit's tax returns, the 990 forms, those are public record. But if you think about it in reverse with things like funding, if they're getting some sort of governmental funding, you would ask the government agency for their records about the nonprofit. So that's a really good tip. There's another question in here about if CFOIC has criteria for whether you'll help with a records request denial. We will help anybody who has a question for us. As far as getting an attorney involved, that's really up to the attorney, and we sometimes run those questions or requests, if they're not journalists, by the attorneys to see if someone's interested in taking that case on. But as far as anybody having a question about anything related to public records or open meetings in Colorado, we will try to help.
Yeah, and I mean, like I said, we provide pro bono legal services related to denial of public records requests to Colorado journalists. Our CFP is primarily geared to assisting journalists. So our services really don't typically apply to public in general. But we have internal criteria for whether or not we will move forward and take a case. We have plenty of great resources, but in some cases, there's only one of us in the state who would take on your case. So certainly feel free to reach out to me if you have any questions or if there's a case that you need assistance with. And we partner pretty closely, or, with Jeff. He'll send emails to a group of us and ask those questions. So feel free to do so.
There was also a second part to Brian Berger's question. It was separately, are communications between a DA and officers on a scene, or DA and sheriff or other elected officials, specific to a person or incident privileged?
That's a good question. That would probably be a little bit better for a criminal defense attorney to step in. But, if the attorney represents the police department, those communications could be viewed as privileged or attorney-client privilege, depending on what the relationship is, at the time that they have those communications or those conversations. But in general, if a lawyer-client relationship exists, then those communications would be privileged.
Or it could be, viewed as a criminal justice record. So, if it involves a case, the DA is working with the police on a case, they may just withhold it as a criminal justice record, but they're supposed to, balance those factors and state their reasons for denial.
Does anyone have any additional questions? All righty. Well, it looks like we've covered all of our questions. Jeff and Rachel, is there anything else you wanted to cover or say before we wrap up today's meeting or webinar?
Only that my email is in the chat and our website is in the chat. And if you have specific questions going forward, please feel free to contact me.
Yeah, and I'll do the same. If you have, any follow-up questions or any other additional questions on litigating public records requests in Colorado, I'm happy to answer your questions. I'll just put my contact info in the chat as well. But thank you for your attention.
Thank you all for the time. And in addition to what Rachel said, this meeting has been recorded, so I will be following up. Everyone will be able to view this. So if you have additional questions that you didn't think of during this webinar, or that you have now afterwards that maybe requires individual time, I'll be sure to link their contact information as well in that follow-up email. Thank you guys again for joining us. We appreciate you being here. All righty. And we want to continue to offer these types of tools and resources to the job seeker database that this went out to, as well as those that are part of the working group, those constituents. So thanks again for joining us today. I'll be sending a follow-up survey. So if there are any other similar events that you'd like, let me know. All right, you guys have a wonderful Friday. It is mostly sunny today, so I hope you guys are able to get out and enjoy the weekend. Thank you all.
Thanks, everybody.
Thanks, everybody.
Bye.